Ma'am, Miss John Bier Williams.
Hello.
Hello, can you turn your camera on for me, please?
Okay.
Ma'am, you don't want an attorney this morning?
No, I am the authorized representative. I'm making a special limited appearance for the all caps name.
Okay. All right. Let me call this matter then. Now calling the matter of the people versus John Bier Sherelle Williams. This is ticket SP 1534898. Count one, no insurance misdemeanor. May I have your appearance for the record, ma'am, please?
Hello. Can you hear me?
I can hear you. I need your appearance for the record, ma'am. Can you hear us? I could just hear you a moment ago.
Hello. Can you hear me now?
Can you hear us? Yep, I can
Yeah,
hear
I can hear you now. Something going on with the phone. I'm inside of a building.
I was about to say it's because you're in the building, ma'am. Can you state your name for the record, please?
I am the authorized representative of the all caps name, John Bier Sherelle Williams.
All right. And it's my understanding today that you don't want to be represented by an attorney. Is that correct?
Yes, I have power of attorney.
Okay. And you know that you have the absolute right to have an attorney. This matter is a misdemeanor before my court. So certain constitutional rights kick in. The fine is up to $500. A possible, I believe, now this one ticket is 90 days maximum in jail, potentially, in these particular matters. So when we start taking away civil liberties, there's a right to have an attorney. You understand that, ma'am?
Yes.
Okay. Ma'am, how would you like to move forward with this? Do you have current insurance, up to date and current insurance?
Actually, I took the car and I put it inside of the business, the trust, and I'm not operating the vehicle now because we need to do some more paperwork on it. I am in the process of rescinding all my contracts. I'm just here to make a special appearance.
Before we even get into the chaos, let's set the stage. Today's case isn't just about a simple traffic ticket. It's about what happens when someone walks into a courtroom armed with internet legal theories, refuses to identify themselves, claims to be an authorized representative of their own name, and believes saying the right buzzwords can override state law. What starts as a no insurance misdemeanor, a charge that could have been resolved quickly and quietly, spirals into a full-blown standoff over jurisdiction, all caps, names, trusts, and sovereign citizen doctrine. And here's the twist. The judge isn't playing along. Calm, direct, and laser-focused on procedure, she keeps bringing it back to one simple question. Do you have insurance or not? But instead of answering, our defendant chooses escalation. And when you escalate inside a courtroom, the consequences escalate with you. Stick around because what you're about to see is how refusing to participate in your own trial can turn a minor issue into a bench warrant and possibly jail time, all in real time.
Okay, so let me let you know. So even if you're making a special appearance on behalf of that, either you have insurance or you don't have insurance. And then you need to tell me how you would like to proceed forward. We can either proceed forward with the plea, proceed forward with the trial, bench, or jury in this matter.
As I understand the process, the judge, the county attorney, or the police officer has leveled the criminal charge with the clerk against the trust using the all cap name.
Ma'am, it's all the same. So whether it's all caps or lower caps, if it comes under your driver's license number and it's a registered vehicle to you, it's your responsibility. So my question was, do you or don't you have insurance at this point in time?
I'm asking you to dismiss the case with prejudice.
Okay, so I'm not going to do that because it's still an open case and I still don't have whether or not you have insurance. It has to be provided. Any vehicles that are driven, road, traveled, on the roads have to have insurance in the state of Michigan.
Well, the clerk, who is the administrator of the CSTQ trust, then appointed you, the judge, as the trustee for the trust. And since neither of you can be the beneficiary, that leaves me. And therefore, you are my trustee.
And there it is, right out of the gate. Authorized representative. Special limited appearance. All caps name. These phrases are classic sovereign citizen talking points. The idea is that the government created a separate corporate entity in all caps, and that the real living person can somehow separate themselves from it. The problem? Courts across the United States, including the state of Michigan, have repeatedly rejected this theory. It has no legal standing in criminal proceedings. The judge immediately understands what's happening here. She's not confused. She's not intimidated. She knows that regardless of how the defendant phrases it, the charging document lists a person tied to a driver's license and vehicle registration. In criminal court, you can't sidestep identity by rebranding yourself as your own representative. The law doesn't operate on wordplay. And already, we're seeing the defendant prioritize ideology over practicality, which rarely ends well in front of a judge.
So as my trustee, I instruct you to discharge this entire matter. At your argument of trial of judge will ask you, okay?
No. So here's your options. You can either plead or you can have a bench or jury trial. How would you like to proceed? Or if you don't want to participate,
I don't want a contract at all. I don't want a contract at all.
So if you don't want to participate, then what we do is the next stage is a show cause or a capias.
So as my trustee, I instruct you to discharge this entire matter with prejudice and award the penalties for these charges to be paid to me and compensation, damages, or for all false arrests.
All right. So it seems like she doesn't want to participate in today's hearing. So I'm going to set this for a show cause on the date of July 22nd, 2024 at 8:30 a.m. If at that point in time, Ms. Janvier Sherelle Williams would like to participate in the hearing, she can return to court bond set at $0 personal. Have a great day, ma'am.
Notice how patient the judge is here. She explains constitutional rights, the maximum penalties, even potential jail time. This isn't some rushed, hostile courtroom. The judge is giving her every opportunity to understand the seriousness of the charge. A misdemeanor with possible jail exposure means the right to counsel absolutely matters. But here's the contradiction. Claiming power of attorney over yourself doesn't make legal sense in this context. Power of attorney allows you to act on behalf of someone else, not to create distance from your own criminal liability. The judge is methodically narrowing the issue. Do you want an attorney? Do you understand your rights? Do you have insurance? Instead of answering directly, the defendant pivots back into trust language and contract rescission theories. And each pivot moves her further away from resolving the actual charge.
Yes, I could bring her in. I didn't really want to argue with her at the front of my docket. I was going to make her wait to the very end. Janvier Williams. Thank you so much. Janvier Williams.
Hello?
Hello. Can you turn your camera on,
Yes.
please?
Yes.
All right.
How you doing?
I'm fine. How about yourself? All right. Now calling the matter of the people versus Janvier Sherelle Williams. This is ticket number SP 1534898. Count no insurance misdemeanor. May I have appearances for the record, starting with counsel, please?
I am here as the authorized
Our counsel,
representative of the all cap name. I am here to make a special appearance, limited special appearance.
All right. So
I'm a foreign entity challenging your jurisdiction.
This is where reality and rhetoric collide. The judge simplifies the entire matter down to a binary question. Insurance or no insurance? That's it. That's the case. But instead of addressing that, the defendant demands dismissal with prejudice. A legal term that would permanently bar the charge from being refiled. That's a bold request in a case where the factual question hasn't even been addressed. You can see the judge trying to anchor the conversation back to procedure. Traffic laws apply to vehicles operated on public roads. Insurance requirements aren't optional based on personal belief systems. The courtroom isn't a debate club for jurisdictional philosophy, it's a venue for applying statutory law. And when someone refuses to engage with the actual charge, the judge has limited options. Courts can't function if defendants simply opt out of participation.
Okay, so I need the actual person, Janvier Williams. So if you're representing her, I need her to be online as well. So if she cannot be online, I can't proceed with this hearing today, and she's going to be capious at this point in time.
Okay, so that all cap name was created by the state of Michigan for public and political purposes. Are you bringing suit to your own corporation? I am a non-resident alien. Listen to me. I'm
here for, no ma'am. I give you very specific things. This is a matter for no insurance for Janvier Sherelle Williams. If she is not present today, I cannot handle this matter.
Okay.
Okay? So is she present
Judge, do
today?
you have any interest in the case of filing a W-9 or 1040 form with the IRS?
No. No. This is a traffic matter for no insurance misdemeanor. And if you're not John Vieira Williams, you don't have any claims in this case anyway. So I need that person to appear, or else this case will be capious today.
I'm asking you to dismiss the case. Charges.
I don't know.
I am an authorized representative. I just told you I'm an authorized representative.
Do you have a P number? Because the only person who can represent someone in court is an attorney. What is your P number, ma'am?
I'm an attorney, in fact.
Now this is an important procedural moment. Instead of immediately issuing a bench warrant, often called a capious, the judge chooses a show cause order. That's essentially the court saying, come back and explain why you're not complying. It's a second chance, a measured response, a cooling off period. And that decision says a lot. The judge isn't looking to escalate. She's giving the defendant room to reconsider and participate properly. But here's the catch. A show cause is still a warning shot. It signals that the court's patience has limits. If you return and continue refusing to identify yourself or answer basic questions, the next step won't be another warning. It'll be enforcement.
I'm asking you to dismiss this case.
I'm not.
If not, I will put a UCC. I will lean it. I will lean it.
Quiet.
John Vieira, Sherelle Williams. Are you present, ma'am? John Vieira Williams, are you present twice? John Vieira, Sherelle Williams.
To make a special limit appearance on
present?
the behalf of
Ms. Williams, if you're not going to answer the question she asked, and don't say anything.
I am here to make a special appearance, limited appearance on the behalf of John Vieira Williams, the agent.
Round 2, and nothing has changed. The same script. The same refusal to identify as the named defendant. At this point, the judge makes something very clear. Only licensed attorneys, those with a bar number, can represent another person in court. You can't just declare yourself counsel because you've studied certain theories online. What's striking here is the judge's tone. She's not emotional. She's not rattled. She simply repeats the requirement. The actual named defendant must appear. If you claim to be a representative, the principal has to be present. That's basic legal structure. And when the defendant pivots into IRS forms and non-resident alien language, it further shows how disconnected these arguments are from the actual charge. A state-level misdemeanor for no insurance.
Okay.
Authorized
so John Vieira Williams is not present.
Authorized representative.
All right. So if she's not present today, I cannot move forward because I need her present. All right. So there will be a capious put out on her zero bond until she appears before the court. I need to have John Vieira Sherelle Williams appear before the court so that I can make sure I have the right person who has this
That
ticket
all-cap name
of
was
no insurance.
created by the state of Michigan for public and political purposes. Are you bringing suit to your own corporation?
Thank you. John Vieira Sherelle Williams is capious until she appears before my court to answer to the no insurance misdemeanor ticket. Thank you.
And here's the inevitable consequence. The judge asked repeatedly, is the named person present? Are you going to participate? When the answer remains evasive, the court moves forward. A capious is issued. Zero bond. That means she will be taken into custody and held until she appears before the court properly. This is the moment where ideology meets enforcement. It's one thing to argue jurisdiction over Zoom. It's another thing entirely when law enforcement shows up at your door with a bench warrant. Courts don't require your agreement to exercise authority, they require compliance with procedure. And the tragic irony? This all stemmed from a ticket that likely could have been resolved with proof of insurance or a straightforward plea.